Okay, the minutes are approved. The agenda I'm sure is approved because it's very, very general. We will get to the circulated draft report in a minute. There are two matters I want to address first that were on the agenda. I want to do them.
Did everybody get cut off from Justice Boston?
Yes.
Yes.
Okay.
Yes. Yeah. His
Oh.
computer froze.
I think he sometimes has connectivity problems at his house, so that actually doesn't surprise me. If worst comes to worst, he can just call in.
I shot him a text to flag it.
Okay. Sounds like you're back, Justice Boston, but you froze up.
Oh, I did? Where
You
did I
did.
freeze?
You froze
Right.
right when you were talking about, we have a couple of matters on the agenda before
Oh.
the report.
Okay, before the report, there are two matters, the statute of limitations and the matter for the Law Enforcement Academy that Zach and Victor and Commissioner Stewart have been so involved in. We'll get to that in a second. We'll deal with the statute of limitations first. As you will recall from House Bill 5, the legislature gave us instruction to answer various questions. We've done that, all but the one of statute of limitations. We simply ran out of gas at last meeting, and so we'll address it now. And I've asked Alex, as our staff, to address what she recommends. We can discuss it and then vote on it. Alex?
Sure. So I looked a little bit at some statute of limitations for federal civil rights law, as well as statute of limitations in New Mexico. And what the research showed is that for the federal civil rights statute for 1983 actions, what happens there is they just borrow from the New Mexico, from any state, wherever you bring the lawsuit, they borrow from the state's personal injury statute is how that works. So in New Mexico, it would be an action under 1983 would be, the statute of limitations would be the same as for bringing a personal injury lawsuit in New Mexico. So based on that, I'm sorry.
Which is what?
What? It's 3 years. So it's 3 years in New Mexico. So it'd be 3 years for a federal civil rights violation lawsuit in New Mexico. So based on that, I would recommend that since this is looking to be a civil rights act in New Mexico, that we adopt that same 3-year statute of limitations.
Questions, anyone? Anybody have any reservations about that? Seems to make sense, or conformity, if nothing else. Anything else on that subject?
Sorry.
Anything else on that, Alex?
Yes, the other issue that I would raise is that in New Mexico, the law for there's the statute of limitations for minors and people who are incapacitated. It gives them a year after they reach the age of majority or their incapacity lifts to bring their lawsuit. And I would think that we should maybe add a reference to that particular New Mexico statute in our draft bill to say that the same rule for minors and incapacitated people would apply. That's under that statute, and just reference to that statute, something like that said something like, for minors and incapacitated people, see the statute that we have in New Mexico for that, which is and that statute is 37-1-10. And similarly, there's a statute in New Mexico for childhood sex abuse. that gives people a certain amount of time to bring allegations of childhood sexual abuse. And the statute is 37-1-30. And what it says is for actions based on injuries caused by childhood sexual abuse, they're commenced before the latest of the following dates, which is the first instant of the person's 24th birthday, or 3 years from the date that the person first disclosed the abuse to a licensed medical or mental health care provider. And so since those are the rules in New Mexico for minors and for sexual abuse cases, I would think we would just want to refer to those in this statute. Say it's 3 years for minors, see 37-1-10, and for childhood sexual abuse, see 37-1-30. Those would be my recommendations.
Okay, questions, anyone? Comments? Reservations?
I have a,
Who's talking?
Zach, I think, or Victor.
Victor?
I'm trying to come back. There you go. Can you hear me?
Now we can, yeah.
Okay. So I have a question. My question is, what is the justification for addressing minors in this context? You know, I'm just curious why we would want to. I mean, I could see a potential where, for instance, when this bill is going to open up something for like education under the state constitution. So is that saying that if somebody felt that they were wrong when they were 15 years old, they're going to have until the age of 19, a year after they turn 18, to bring this up?
I think potentially, yes, it could mean that. I think that person would no longer be able to. I don't know how this would play out in an education case, but I would think that yes, that's what it could mean. But I think that for minors in New Mexico, that's the way the law treats them under 1983 anyway. I think those same rules would apply in a 1983 action currently. So that would be the answer, I think.
Anyone else?
I think the other place, Victor, it may come into play is in, you know, if a kid was abused in jail or CYFD, like if there was sexual abuse or something like that occurred, it would protect those types of claims to be brought when they're an adult.
Right, makes sense. Anyone else? Okay, rather than do it individually, I'll just have a show. Is anyone opposed to the suggestion that Alex had made? Doesn't seem like there is any opposition. Okay, then Alex, you understand we have approved your suggestions?
Yes, and I'll circulate a new draft bill that includes the 3-year statute of limitations and the references to those 2 statutes.
Okay,
You know,
thank you.
this is Judge Whitaker. I guess my only question is almost in an abundance of caution, you know, shouldn't we include, we can mirror those particular statutes, the language, but I'm almost thinking we should put it in the body of the act just to prevent any modifications, frankly, of those statutes that then would have to be incorporated into the act. So I'm almost of a thought that it should be sort of the act should be self-sustaining and self-sufficient with regard to those issues in the act itself. It could mirror that language, but should be I think it should be contained in the act itself as opposed to referencing it outside of it. That's just my sort of knee-jerk response to it, just in an abundance of caution, just in case there's some level of modification of any one of those in the future. So anyway, those are my thoughts.
Comments? Any opposition to, I'll take that as a proposed amendment, Judge. Any opposition to the amendment?
You know, I don't want to make the act any longer than it is. I mean, we want to keep it fairly, you know, straightforward.
Yeah, I will say that both of those, the first statute, the one for the minors, that's pretty cut and dry. So adding that text would not be very difficult. It's only, sort of one long sentence.
Right.
But the childhood sex abuse one, besides the part I also read, it has definitions for childhood sex abuse. And so it's just a little longer, but I mean, we can certainly add the text, but just letting you know.
Those are my
Okay.
thoughts. I mean, it's a
Anybody
stand-
opposed? Anybody opposed to the amendment? All right, then it passes.
Yep.
Alex, you understand, right?
Yes, I will put the language of those two
Right.
statutes within our bill.
Okay,
If
Thank
we're gonna do the specific language in the bill, I think we might want to consider addressing the abatement issue,
which is? what
which
that?
is then an action would just have a sentence that says an action would not abate upon the death of the public official.
That's a standalone statute now, isn't it?
It is.
Any objection to that? Okay, then we'll put that in as well. I think that
Okay.
concludes this subject. The second subject that was on the agenda is broader. I have the impression that Zach and Victor and Commissioner Stewart, Kim Stewart, have done a lot of thought, put a lot of thought into the area of law enforcement education and improvement. And if you remember, our last witness last time was the head of the Law Enforcement Academy, and who put forth a pretty long list of problems at the Law Enforcement Academy, things that she thought needed addressing by the legislature and the governor and so forth. And they would like a report to contain some reference to that, and they circulated a rather lengthy email, or maybe more than one, on that subject. Zach, if you don't mind, could you explain what it is you have in mind?
So, I really want to defer to Victor to kind of explain and Kim to explain. I was really more of a scribe in this process. They're the ones really with the knowledge of it. But what stuck out to me from the presentation was that it's clear that that there needs to be some restructuring of the Law Enforcement Academy. I try to put the recommendations into sort of 4 big buckets. That there's concern about its structure because it's administratively attached to the Department of Public Safety. And then, as a subpart of that, I thought it was clear from the presentation, they absolutely don't have the authority to enforce their compliance with their policy directives and their recommendations. And they don't have the authority to get the subpoena document. I mean, it kind of blew me away. I mean, in our own rules, if I ignored an inquiry from disciplinary counsel, I'm done. I mean, it was striking to me that a request from the director of the Law Enforcement Academy for documents responsive to a complaint could go unanswered, and there's no mechanism for them to deal with that. And then the other, I'll kind of defer to Victor to explain some of the other things too. But more than anything, that's what stuck out to me was this lack of power that they have to even enforce the regulations that they have. And I thought it was alarming. My understanding is that there's a lot of support for these changes within the law enforcement community, and I'd sure like to be supportive of those recommendations and have the commission be supportive of those recommendations. I think the database has been talked about a lot in terms of maintaining a database for misconduct, because it hurts both. I think Mr. Byers helped explain this with his questions the last presentation, that it hurts both the victims in terms of having their cases prosecuted, and it hurts law enforcement agencies being able to prosecute cases, and they need help on the hiring decisions and disciplinary actions, and they don't have a database to track police misconduct. So it sounds like it's another area where there should be a lot of support, and I would hope that the commission could make those types of recommendations. And then my understanding is that funding has been chronically short for the LEA, and I thought we heard enough of that. I mean, it looked, if I remember correctly, the testimony was that 8 out of the 20 positions were filled there. That they don't have anyone that acts as a custodian of records to do things like field IPA requests. And it seems like the resources that were made available were very stretched, very thin. And the director seemed like a remarkable director that is doing all that she can within the structure that she was given, but she certainly needs to be empowered more. And so that's really where this stuff came from, and was my discussions with Sheriff Stewart and Victor. They really educated me on these problems that my understanding has really seemed widespread. And I'd really defer to Victor to kind of get in the weeds a little bit on some of these things, because this is really their wheelhouse, Victor and Kim.
Victor, your thoughts?
So I think everybody saw the email that Zach sent out. Zach, thank you very much for doing that. He pretty much put a lot of the information that myself and Sheriff Stewart drafted and put it all in an organized manner, which is one of the many qualities of going to law school. Was able for the rest of us. We kind of jotted some things down on email. One of I'll go over them real briefly, and then I can answer any questions that the rest of the commission may have. One of the recommendations that we felt was appropriate was the separation of the LEA from underneath DPS. I think everybody knows that currently DPS has 2 law enforcement agencies underneath them, or actually just 1 now. They're all state police, but there used to be 3 of them. But there is a law enforcement agency under DPS, which kind of gives that perception of the police policing the police. And as most state entities that deal with peace officers training and standards, it's a whole separate entity. Outside, it's an executive adjunct agency through the executive office, and that's kind of what we feel is probably one of the better things. The other thing is meeting more frequently for the board. 4 times a year. I think if anybody has been paying attention to the news stories that have been coming out, which have been quite many of them in law enforcement, one of the biggest problems is the backlog that the Law Enforcement Academy has had. And there's cases in there, I think I saw from the last story 7 years ago. There's even a person that I recognize that's on that list that's currently in prison, doing prison time, but they still haven't revoked their certification, which to me is just unheard of. How a person can be sitting in prison and we're still debating whether they should be a police officer is beyond me. And so that was another reason, is that getting that backlog going. And the only way you get that backlog going is by getting the governing board to meet more frequently. And so the suggestion was to raise the number of times that they meet from 4 to 6 years to try to get some of that backlog going. We spoke about adding additional membership to the board to provide a little bit more a little bit more transparency, to include a psychologist, individuals, executive members from cities and counties that actually, so they can see what happens, right? Because I think Sheriff Stewart touched on this on our last meeting, that sometimes it's very difficult when you're the department head, you're really not the department head, because there's people above you that make the decisions when it comes to trying to hold these bad government actors accountable. And so then the other thing was to add a dispatcher. For a lot of people don't know, but the Law Enforcement Academy also licenses dispatchers, not just police officers. and they currently don't have any representatives on there for the dispatchers. The other thing was, by them being separated from DPS, having their own a little bit more independence with investigations and prosecutors. I think we heard from the LEA director that they're very limited when they get information. They're very dependent on compliance from individuals, from the individual agencies. So they're more on the will you please help us instead of you're mandated to help us. And I think that by giving them those resources of investigators and prosecutors, that also allows them not to have to rely on the Attorney General's office, which by my understanding right now, they only have one prosecutor assigned to prosecute all of these cases. And so I can attest myself that I was supposed to appear in a law enforcement academy hearing last week, and it got continued. And it's been almost going on a year and some change from the initial referral. So, trying to get those things going. I think Zach touched about the power from law enforcement from subpoenas. Also, that where it's just not all bark, but there's some bite to it. In other words, where the academy actually has the abilities to sanction not only individual officers, but also agencies that refuse or that do not comply with training or the requirements under disciplinary referrals. So that's another thing that we would be recommending, is that there's actually some teeth to some of these administrative codes and statutes that require people to comply with the law. Trying to shorten, I think the time was another recommendation. I think when I heard to the director, there are some time constraints, but for realistically, I think, like I said, if you've been listening to the local news stories that have been coming out, some of these things have been pending for years. And so I think they need to be a little bit more stringent on getting these things from one process. I mean, in the courts, we have the 6-month rule. There's no reason we shouldn't have something similar to that in these hearings and get these things going through a speedy trial while at the same time trying to preserve due process. The other thing that we talked about is clarifying some things like good moral character. What does that mean, right? Things, being very specific and giving a glossary of what is it that we exactly want. Because I think when you leave these generic terms, it leaves up to subject of interpretation of the individual leader of the agency to determine whether they believe it fits that term, thus resulting in some of these referrals not going through. Because the agency believes that doesn't meet a good moral character type of term. The other thing is, of course, we talked about the database, not only on making it, not only on getting it up to date, but a database that also is available for people who have had sustained findings of excessive force, lying, other behaviors. To allow individuals to, that way we don't have individuals going from agency to agency and they're being hired. And like I said, if you listen to the news, you can see very quickly that these guys bounce around on disciplinary issues and wind up, because sometimes it's easier just to get an officer regardless of, and overlook their history so you can have somebody on the streets. And I think that's the problem that's gotten us into this position. And obviously, with any of these things, we want to make sure they're not just unfunded mandates, that we fund them, that the legislature funds them fully so that they actually have the ability to implement these recommendations. I think that pretty much covers the majority of it. Do you have anything to add to that, Sheriff Stewart?
Sheriff Stewart.
Yes, thank you for opening my mic. I appreciate it. I don't want to repeat what has been said because it's both Zach and Victor are very accurate. I do want to say that I strongly believe that if this any LEA entity is strengthened and it actually has some teeth with agencies, you are going to see a great deal of improvement in overall policies and procedures. I came into a sheriff's department where policies and procedures had not been updated since 2001. There had been no pressure anywhere in our system to keep those policies updated, to keep us in line with best practices. That's a challenge I've worked on for 2 years. I do know something from having worked with employment lawyers myself, that the first place you look, correct me if I'm wrong, I'm not an attorney, the first place you look is to policies and procedures in order to make a case. And I think you're going to see significant improvement if indeed the legislature accepts our suggestions. You will see actually more improvement out of this than you will see from some of the other suggestions you're making. So thank you very much for the time.
Okay, anyone else have any comments or questions or anything? How would we do this?
Justice Boston,
Yeah,
if I could, I just wanted to weigh in on one suggestion, and it's just a slight bit of discomfort I have. I'm all in favor of including language in the report that highlights the need to give the LEA teeth, to increase its resources so that it can act in a meaningful way. My only pause is on the level of detail that we're going into, because, for example, I don't know the feasibility or benefits of a composition of a board that includes a psychologist and a dispatcher or not. I feel more comfortable within my knowledge from what we learned from the presentation and what we know from some of the criticisms that have been out there, that it's important to highlight that the legislature look at and address this issue. But I just don't know that I know enough to evaluate the specificity with which some of these are written. And so my suggestion would be that we include a section, an appendix that addresses this, but that it remain at a more general level, highlighting the need for funding and to give the organization teeth without getting down into how regs should be written or the specific status that would have related to other cabinet level positions, because it's just a lot to bite off. And I don't know that I've heard enough to know the basis for each of those. I'd be much more comfortable with the emphasis for the legislature to tackle it. I also think that that would be more in line with the scope of our statutory mandate, which we're reaching a little bit to get to this, although I think it's worthwhile given how important it is to do that. That would be my overall recommendation, is that we tackle it, but we do it at more of a please consider additional funding and teeth rather than each of the specific bullet points that have been laid out, all of which may have a ton of merit. I just don't know how to evaluate all of them.
I would be interested to see, Senator, to see your take on that. I mean, in terms of us presenting this to the legislature for consideration, do you have some insight that would be helpful as we consider? Because I agree. I think that the director had a compelling argument of being underfunded and under-resourced to do their job. And I think these are suggestions from Zach and from Victor and Sheriff Stewart. But how do you see that coming to the legislature?
Well, I think that the premise of this whole commission was to present some credible legislation to the legislature. Even though this wasn't specifically our charge, I think that the legislature will at least look at it seriously. And the key here is to get some credible sponsors to put together the legislation that needs to happen. And this would just be additional ammunition to help carry that forward. So I think it'd be very useful. I think certainly I think this is something that's, and I agree with what I think as Victor said, this may be, or I'm sorry, I think Sheriff Stewart said, this may be more credible or more useful than some of the other things we've been considering, because if we can get some of the things resolved in terms of dealing with the bad actors, I think we can accomplish a lot more there than in terms of serving our citizens of the state, if we can get that done. So that's my thoughts.
So if I understand correctly, and I would be in favor of the LEA issues that we just talked about being recommendations, because all of these recommendations that I've just heard, of course, I think are going to be helpful. But if I understand clearly, they won't be part of the act that we're recommending. Is that right?
I don't think it wouldn't be appropriate to be part of the act anyway. I think we'd be looking at totally different sections of law, and Raul can answer this better than I can, but I think when you start crossing over too many segments, you can, what do they call it, log rolling or something to that effect, and we don't want to get into that. I think we need separate legislation. And if you want to make a strong recommendation that we do some of this with some credible bullet points of what needs to be in it, then we find somebody that's the right person to carry that kind of legislation, and we go forth with it that way. But and it can be a function of this commission, but it doesn't necessarily have to be part of our legislation we propose.
Okay, thank you.
Raul, do you want to comment on that at all?
Thank you, Mr. Chair. I think Senator Neville is correct. It is log rolling. It is in the Constitution. It's specifically the single subject provision. And you do have to be careful not to put in something that could be two distinct provisions, two distinct bodies of law, if you will, that are not as related or would raise questions about log rolling. I don't think I have much more to add than that. But if there's any question, I'll be happy to spend some time with Alex on that issue. We've got some background on that.
Victor, Zach, Sheriff, do you want to respond? I think it seems to me that we're all in agreement on the general subject that we should make a recommendation. The degree of specificity is a matter of degree. How do you want to handle that?
May I, Mr. Chair?
Sure.
I agree. I mean, these are merely suggestions. I didn't have any idea that they'd be in an act and we would be writing the law. That obviously is, I thought these were basically all suggestions for consideration. As to specificity, just in my short time, I've seen some very, very poorly written legislation that has left people in my profession in this state unable to actually carry forth the intent of the law. And I point to the red flag law, I can point to the body cam law. They are written by individuals who I think in good faith believe they understand law enforcement. But from what has been written, it is clear to me that there is a grave lack of knowledge about how things work. So I would prefer, or at least promote, leaving in some specificity, because there's at least 3 of us on this commission that do have some experience, much as we have looked to you attorneys for your experience. We can be fairly certain in our function as to what specifically would help the board. Thank you.
Let me make a proposition. I also agree that we should address this, and we should address it in the report, not legislation. We're not there yet. The only question here is degree of specificity. Why don't we vote to approve the concept? And I'll ask Zach, Victor, and Sheriff Stewart, or one of them, to have a sort of a sidebar discussion with Mark, and maybe they can just work out the degree of specificity. What do you think about that? Is that okay?
That's fine. Yeah.
With that?
The only thing I have to say, Mr. Chairman, is that the degree of specificity on these recommendations came about from the testimony of what I heard, not only from the LEA director. I mean, these were what she was mentioning were issues. I don't think you can get any more specific than the person that's running the organization. And unfortunately, this is one of the downfalls that we have, because we have lacked discussion on a lot of these issues. And unfortunately, we're answering these questions at the 11th hour that we probably could have answered if we would have had more discussions as a commission.
So, Justice Boston, on that point, I just have to flag that we opened up from the beginning for everyone to present any witness that they wanted to have presented. and we agreed to have everyone heard. So I would take issue with the idea that people haven't been heard. I'm happy to work on specificity issues. I also am happy to be voted down if the will of the majority of the commission is to vote in favor of the specific proposals that are there. I've got no qualms about that. I mean, I flagged my one concern, which was not feeling like I know enough to go beyond general recommendations. But if it's the will of the commission to include all of this, I'll sleep fine at night with that.
Well, let me put it to the commission then.
I have a
You all have-
suggestion.
Yeah,
And I mean, this might be a way that we can do it all that makes folks feel comfortable. I think that the formal recommendations could be those top bullet points, those 4 bullet points. And then we could reference this document in the appendix and just say that in consideration of these recommendations, the legislature may want to consider these things, and the commission doesn't have to take a formal position of endorsing or not endorsing those specific things, but we are recommending that they look at those bullet points, those 4 bullet points. And then we get the sort of specificity that we want them to consider. And the commission's position is that, yes, you should look at these broad issues.
I'd be perfectly comfortable with that.
all right, good, thank you. Then, like before, I think we have a consensus that we should proceed on this. Is there any objection? Okay, hearing none, then I think, I hope it's specific enough how we proceed on this. And thank you again to Zach, Victor, Sheriff Stewart, for bringing this to our attention. It is something that is not specifically included within our mandate, House Bill 5, but I think we would be neglecting our duties if we didn't recognize the testimony, a very compelling testimony that we heard the other day. Okay. Alex, is there anything remaining that we need to address?
Yes, I think one thing that you might want to discuss is in the bill that the draft bill that I circulated has a section regarding making sure that the any settlements or judgments are able to be accessed through the Inspection of Public Records Act, and that the entities would keep those. And I thought we should probably discuss that.
What are you recommending?
I recommend that be part of it because I think it's good for transparency and accountability, but I thought that we should discuss it, or you all should discuss it as a commission.
Any thoughts?
I would think that if it's not addressed, it would be subject to disclosure. And I mean, there's a prohibition somewhere. Is it in the Tort Claim Act that prevents settlements from being confidential?
I'm not sure where it is, but I know there is something that says that they can't be confidential. My understanding is that at least at one point it was for 6 months they could be kept confidential. I'm not sure if that is still the way it is or not. I think this provision would just make it clear. It would also clarify that people have to keep the final judgments and settlements together with a complaint so that whoever requested the documents could receive them in a way that they could evaluate. But I agree that I think that people could access these under the Public Records Act regardless.
Any more thoughts?
May I ask a question?
Yes. Mr.
I
Bach.
was just, thank you, Chairman. I was just wondering, I understand that the desire is to retain the copy of the complaint and the settlement and make it available for public inspection. But there's an aspect of that also that involves the Inspection of Public Records Act, which then becomes, which is being used to no end to create an issue for public entities as it is right now with responding to records requests under that act. And it's my understanding that at least one law enforcement agency that I've been informed by members of that law enforcement agency have come under increased attack or scrutiny through the use of the Inspection of Public Records Act process, and it is draining their budget. And so what I'm seeing is that there's a potential for a double penalty here with regard to the implementation of this new cause of action for government agencies. And so that just makes me ask the question, rather, other than transparency, what would the purpose of this requirement be? Thank you.
From my perspective, I think that's the whole purpose, would be transparency. So that was all the thought behind that.
I see. Well, I think that the current status of public records retention mandates that government agencies require that. So I'm not sure if we're just being duplicative. I could be wrong.
Anyone else?
So having brought and defended Inspection of Public Records Act cases, from my perspective, the benefit of this is that it tells the agencies to have it compiled, and otherwise you end up in a situation where it's like, well, it's overly burdensome and how long is it going to take? And then people get sued even though the records are there if it takes too long to get them back because of the delay. This just says keep your ducks in a row on these issues so that when people want to see the status of settlements and judgments and the basis for those by looking at the complaint, it's all compiled in one place. I think that you're right, though, District Attorney Byers, that the Inspection of Public Records Act would treat these documents as public as the law stands now. So it's more a matter of housekeeping, instructing that they're going to be kept on file and handy so that they're pulled out of a drawer instead of having to somebody ask for it and have somebody scurrying around trying to find it all over a period of time.
So Commissioner Baker, thank you. If I understand your explanation correctly, because I have not brought or defended an IPRA claim, but our agency has been on the receiving end of all kinds of the requests, and there is a lot of flurry of activity. So if I understand your explanation correctly and Ms. Smith's intent correctly, this would push government agencies toward better record keeping with the ultimate goal in mind of not just transparency, but better service to the public with regard to the management of our documents. Am I sort of getting a loose grip on that okay?
You probably said, Commissioner Byers, you probably said it better than I did. I mean, it means that people will have access to this in a easier fashion, both within the agency and outside.
And I would think that it might be helpful for entities as well to be able to see what the settlements and judgments look like, you know, for each agency in a given time period if they wanted to be able to look at that kind of stuff.
Trend analysis. Okay,
right.
I understand. Thank you.
So if I understand this correctly, this is just this is that last sentence that you wrote on the draft bill that pretty much just says that it's covered under IPRA, so go ahead and have it available.
Right. Yeah, it doesn't create another cause of action. I mean, somebody could bring one under IPRA, but it wouldn't create any kind of new thing. The thought behind it was this would be a way to make sure that things are kept in a fashion that would be easily accessible and also would be something that people could analyze for trends if they wanted to see how particular entities were doing. To say this one had, you know, this many things against it. It might be a way to look at that, which I think again would help with the transparency and accountability.
Anything further? think seems like we're all in agreement. That it's already required by the law, and we're just kind of giving a reminder to the entities governmental entities, as to what they need to do, so that they'll be up on it, prepared, and will reduce costs ultimately. So I guess I'll put it to the commission the same way. Does anybody object to or including something to this effect in the, would that be in the statute or in the report, Alex?
I had put it in the draft bill. It could just be a recommendation in the report, or not.
Well, if it's in the bill, let's say, does anybody object to it being in the bill? All right, that should answer your question, Alex.
Okay.
Unanimous. Anything else we need to do?
No, nothing at this point, other than talking about the report, which I think you had on the agenda.
Right. It's a lengthy report. Some of you may not have had the opportunity to review it. Perfectly understandable. There are two parts to it. One is a lengthy, detailed report with exhibits, appendices, a lot of the matters that were put into evidence by the various presenters, and so forth. And then Mark took primary responsibility for developing an executive summary, which I really like, because it's our experience generally that those executive summaries, sometimes that's what gets read and the other does not, just because there's no time. So between the two, I think we've got all the bases covered. It's our goal to submit this report, finalize the report, and submit it to the legislature, hopefully by the end of the week. Alex thinks that's doable. If it isn't by the end of the week, very quickly thereafter.
And you
So
mean the end of next week, just to clarify.
Yeah, next week. So
Tomorrow's fine.
You still have time to submit your thoughts in writing. Submit them to Alex. Anybody else you want to, that's fine. I welcome input from anybody on any respect about this. If you want to go off on the computer and think and reflect on it. Otherwise, if anybody has any comments today, you're welcome to. I'll throw the matter open if anybody wants to talk about the report.
I have a couple
Commissioner-
of things, Chairman, that I wanted just to address. Can you hear me?
Yes, Commissioner Rodriguez.
So just because we are going to have a dissenting report, I would wonder if that it would be appropriate to, on the executive summary and anywhere that it refers to where there was not a majority vote, that it states that the majority of the commission recommends, because not all the commission agreed on some of those issues.
Alex, can you do that?
Yes.
I
And
think
then
that's-
the other, I've got a couple of other. I guess this next one's more of a question that came to my mind as well as we were going through this. So my understanding is that absolute immunity, because we've talked about qualified immunity, but absolute immunity is also a judicial created doctrine that shields public officials such as judges and prosecutors from liability, similar to qualified immunity. That's the way I understand it. And so under this proposed legislation, it says that a public body is pretty much anybody who is receiving public funding, which would involve our courts and our district attorneys that receive public funding. And so my question is, since this bill says that a public body or a person acting on behalf of a public body cannot raise qualified immunity defense and the deprivation of rights, does that mean that if a judge or prosecutor is sued under this legislation, that judge and prosecutor can still use absolute immunity, or is absolute immunity off the table?
Well, just speaking, I've had it over my career. I've had an opportunity to address questions of immunity. Generally, I can think of three groups of people who have absolute immunity. One are judges, insofar as they would be interrogated about their official actions as judges, nothing relating to their private life, obviously, or anything like that. I think district attorneys share a similar immunity. I think legislators share a similar immunity insofar as it relates to their legislative activities, and particularly those while they're serving in the legislature or committee. And those stand independently, and I don't think anything this commission recommends or the legislature does in regard to qualified immunity would affect that at all. They would remain. And there may be other examples of absolute immunity. Absolute immunity is somewhat rare in the law. Anyhow, so I don't think there would be a cross-reference there. Those doctrines will remain intact.
And the reason I bring it up, Mr. Chairman and Commissioners, is because, so if what we're dealing with here now is qualified immunity being on the chopping block, right? That the public employees cannot, use qualified immunity as a defense. And so by what I understand is the same notion was used when this judicial doctrine was created for absolute immunity. And what I'm trying to make sure that we're not creating what is a double standard, why a police officer, a firefighter, a paramedic, a nurse, a teacher who have to make decisions, do not have the ability to raise qualified immunity, but yet there are still public official professions, judges, legislatures, and prosecutors that have the ability to use a similar type of created judicial doctrine as a defense in comparison to other public. So to me, it's, it can give the impression of a double standard.
Mark, you want to address that?
So I think the primary difference would be that, well, I guess there are two. The first would be that the nature of a judge, a legislator, or a district attorney's interaction with the public is fundamentally different. They're making decisions in a courtroom regarding process, and they're only protected by absolute immunity in that role. So if you took a judge and he stepped off the bench and he assaulted somebody, you're not going to have an absolute immunity apply. But for the judicial process, in terms of how they make their decisions, you have to have an immunity so that you don't have somebody sued in court for the way that a judge handled their suit in court, and it can fall and cascade from there. Similarly, prosecutors have to make criminal justice decisions regarding charging, and if a DA stepped out and threw someone to the ground, they could be charged for that. If they violated someone's free speech rights, they wouldn't have immunity from that. But if in their prosecutorial role, they have to make decisions related to the criminal justice charging process and prosecutorial process, that's a different function, and that's where the immunity applies. With legislators, likewise, if they do something independent of their role in deliberating over legislation, I don't think that legislative immunity applies, but it protects taking the legislative act into a courtroom and challenging it there. And so I think while they may both be judicially created immunity doctrines, they're fundamentally different in terms of where they come into play. The second thing is you don't have the problem of the problems that have arisen that have led to the criticisms outlined in the report related to absolute immunities that you've seen flagged for qualified immunity. And I think that also relates to the difference in the way the claims against a judge, district attorney, or legislator for performance of their duties arise versus other public officials. That's my take for what it's worth.
Any other comments?
I'll just add something to, yeah. One of the things I think is important to understand too is that our action on qualified immunity doesn't impact that defense under a 1983 claim in federal court. And I think that I don't understand that qualified immunity has been adopted as a defense for an action under the New Mexico Constitution, which was pointed out by the Santa Fe County Attorney. And so we're not taking away qualified immunity as a defense under the federal civil rights statute. That's not something that we're doing. We're not importing that doctrine into the New Mexico Civil Rights Act. And so I think it's an important distinction to make. I don't know if that helps understand some of that, but I wanted to say that.
Thank you, Mark and Zach, for commenting on that. The other thing I wanted to talk about, Chairman, is that I don't think we ever addressed it. I know I know you had brought it up on one prior meeting, caps. I don't think that was clearly defined, and so I'm asking for clarification. Is under this proposed state civil rights act that the majority agreed with, was there going to be an identical 1983 on the federal side with no caps, or we weren't going to discuss anything about caps?
Oh, caps. I mean, damages caps.
Yes, sir.
Yeah, that did come about in the discussion at various points. That wasn't a specific question that the legislature asked of us, but if we want to talk about it, let's talk about it. Do you have a suggestion?
No, I was asking. The only reason I was asking is because I've had people obviously that have listened to our meetings, our last one, and that was a question that was posed to me as well. What about caps? And so, I mean, I think we had spoken about it initially when you had brought it up, and I think Senator Novell brought it up in one of our first meetings, that it be somewhere similar to the New Mexico tort claims, or maybe a little bit above that, but not too far from it, and not that it be open, that it just be an indefinite number.
Anyone else?
I do, Mr. Chair. I also recall that it was very briefly discussed, and I believe I even spoke to Alex briefly about it out of the commission's presence, that perhaps the caps issue should be addressed. I believe the caps hadn't been changed for many years, and probably it was time to look at something like that. I'm not opposed to being open to that. I mean, I saw that as a pathway. Perhaps we could be a little bit more negotiative at the beginning, if that's a word. But maybe that ship has sailed, but I do agree with that.
Since
We lost him again. Will you text him, Mark?
Those freeze frames always catch great images of people. No matter what, they're always good.
all right. Can you hear me now?
Yeah, we got.
Yes.
This is the third time it's happened. I really don't know why. Just a little
Chairman.
Yes.
Chairman, I'd like to get Senator Novell's opinion, obviously, as a legislator, to find out what his thoughts are as the caps, and possibly leaving them either. My thoughts is leaving it close to what the torts claimed, or whatever. What his thoughts are.
Well, I guess my thoughts go back to my experience as a city commissioner and county commissioner. And if you don't have some reasonable controls on what we do, we could seriously impact the ability of these smaller entities to provide services from the standpoint of law enforcement anyway, and possibly other entities too, schools. This is a wide open act, so it encompasses all public officials. And that would be my biggest concern from the standpoint of what it's going to do to particularly the smallest entities that are maybe have a 2 or 3 man police force, or even 10 or 15 or whatever. Even now, the city of Bloomfield has been negotiating with San Juan County to take over their law enforcement function because of the cost. If you impair that even more with a substantial insurance bill or whatever it might amount to with this legislation, it could be seriously reducing the coverage of law enforcement all over the state. I think a reasonable cap might be something we really ought to discuss and put some thought into. We're at $1 million under tort claims, $1.05 million, I guess, under tort currently, and maybe that's out of date. Maybe that number needs to be bigger, but we certainly don't want to get carried away on this new cause of action.
I do remember this came up in the context of the discussion with the insurance people, people
Right.
from the city, the counties, the state, so forth. And I think I put something, they were afraid it was the excess insurance coverage that really bothered them if they couldn't
Right.
get excess insurance coverage. So I said, well, supposing we kept it at the $2 million, which was the amount that insurance was provided for internally. So they wouldn't have to worry about excess. And the spokesperson said, yeah, well, that would really help the insurance situation. That's what I recall his answer being. And certainly if I were to address a legislative committee, and that may happen in the coming weeks, when we got to the subject of cost, that would be one option that I would propose to the legislature that could consider this. Now, whether we want to propose that up front or whether we want to include in our report some reference that though this is not our recommendation, it would be an option for the legislature to consider, something like that. It's kind of up to us to decide what we want to do.
The other question I think we need to answer is, if we did say a 2 million or any number you want to pick, does that include the coverage for punitive? Does it include attorney's fees? Does it include the claim itself? Or, are they separate items? That's something I think we need to define.
Punitives, of course, were voted down, so that will not be in our
Right.
recommendation.
That's true.
Attorney's fees, of course, yes, and that's a fair question. Anybody else on this topic? Denise, you must have something to say.
I have lots of thoughts on it, but I don't know that we spent enough time on what to do with the cap to make a solid recommendation, other than it definitely needs to be looked at because it hasn't been increased in some time. So I think it needs.
How about this? Unless somebody wants to take an up and down vote, yes caps, no caps, and at what level? How about including in the report, in discussion on costs, expenses, that, as you know from the draft, it's somewhat vague and all over the map, because that's what the testimony was. It's vague and all over the map. But the legislature has different options to consider in terms of controlling costs, and that would be one, and just leave it at that. That's a possibility, rather than take an up and down vote today. What do you think about that?
This is Commissioner Byers. I would agree with the chair's recommendation.
I think we need to specify in the report that if we don't put in the legislation, that the legislature needs to seriously consider a cap because of the ramifications down the line for our entities. The local entities are the ones I'm concerned about. The state can probably afford whatever they need to afford, but the smaller governmental entities around the state, they can't.
That certainly was the testimony. Yeah.
And would this cap, Chairman?
Pardon me?
would this cap, Chairman, include everything, including attorney's fees and all the compensatory damages, or is that separate from the cap?
It could be either one.
I would hope it include I think it should include everything. They need to have a marker to determine what they're going to be paying for.
I agree. I mean, that's the only reason I'm asking, is I just want to make sure that we don't have a this and that. I mean, I know we're, as I said, in the 11th hour trying to discuss something we should have probably discussed, but I think I agree with Senator Neville. I think you have to be pretty specific, and or at least recommend the specificity of it, so that they're aware that we have brought it up as a concern, and that way it's not just, you know, a free for all.
Well, what we did recommend was compensatory damages, attorney's fees, and no punitive damages. The fact that there's no punitive damages, you know, kind of limits where we can go. I mean, the compensatory has to be proved, attorney's fees have to be proved and actually approved by the court. So I don't consider it to just be completely open, which could possibly be if we would have recommended punitive damages.
Mark?
I mean, building on that, right now the language provides for people to be recovered for the harm that they prove they've actually suffered, and nothing more than that, plus the attorney's fees reasonably incurred to prove the violation. And so the idea of, I mean, I'm fine with a reference to caps being a possibility in the list of options to address any increased costs that we have in the report. But to say that we strongly recommend it or encourage it, I wouldn't really be on board with, because to my mind, when caps kick in, it's in the most serious cases when someone's been seriously harmed, and the choice that's available to the public body is to say, or to the legislature is to say, who's going to bear that cost? Are you going to put it on the back of the person who was harmed by government misconduct, or are you going to put it on the government to compensate that person for the harm they suffered? And so if we start getting into modifiers of to strongly consider, or minorly consider, or overwhelmingly consider, I'm going to have some heartburn. But if we just put in a reference to the idea that it's an option, if the cost projections show that it's of serious concern, then I'm okay with that addition. I just don't want to go beyond it.
And the other, I don't know what the dissenting report is going to include, but this is something that could be included in their report.
Anyone else have any thoughts, comments?
I would just say on the separating the attorney's fees from the damages provisions, I think it's important to keep them separate, because one is designed for the compensation of the injuries that the person has incurred, and the other are part of the cost of bringing a lawsuit. And I do think that they should remain separate. I'm of the same mind as Mark, and with the suggestion that I think it's obvious that the legislature can consider that, and I imagine that that's something that they will consider. And so I think mentioning it in the section on the costs, I think is fine. I don't think it should be part of the legislation, though, or a formal recommendation one way or the other from the majority report.
I think what I hear is we have a split as to whether to attempt to recommend a specific number or a broader recommendation or a broader reference.
Well, I don't, Mr. Chairman, I don't know what the specific number needs to be, but I think we need to analyze that and determine what a reasonable number would be. And it could be separate. You could say attorney's fees not to exceed some number, but not for us to determine as a commission meeting on a few brief moments here, but with some more analysis. I think you could consider caps in two phases if you had to, but I think it's important. Otherwise, we're going to get ourselves into a real bind, in my opinion.
Anything more? It's hard to determine where to go on this. Clearly, we want the report to contain some reference to the testimony, which was one option the legislature would have on the insurance subject would be to consider some cap. And particularly so that excess insurance would not be implicated. But without a recommendation one way or the other. If we want it, I think that at minimum, we're going to do that. If we want to have a vote on whether to have a recommendation and a specific number, then we can have a vote on that. I need some guidance from the commission on this.
Chair Bosson, I'd make a motion that we add a reference in Appendix 6 under costs and insurance in the majority report that indicates that if the concerns over reinsurance and costs are established, that a cap be considered by the legislature as a possible solution. Not worded exactly that way, but that sentiment, and then full stop.
What do you think about that? What's the commission think?
Justice Boston, I would second that, and I would just add that one of the reasons I think it's appropriate to do it that way is because we haven't had a robust discussion of the numbers and that sort of stuff, and so I think that that's an appropriate way to handle it.
Yeah, we've had a lot of testimony on a lot of different topics. We couldn't cover everything, and that may not have received the attention that it should have. But after all, we're just the first step here. Whatever we recommend, the legislature is going to take a real cold look at and sharp look at, and they can make their own decisions, and they will. I'm sure they will.
I've served on a number of these kind of things, and half the time, more than half the time, what you see doesn't happen. So, or what you recommend doesn't happen.
Right.
But I would agree with what Zach said, except that I would hope that you would include that in the executive summary as a point, a valid point.
Mark, any objection to that?
I guess I would just stand with my motion because it's one of a list of possible solutions. So including it in the report, I have no problem with that.
Okay. And I think
Can you repeat it, Chairman? The motion at least on my end, there was a feed issue, so I didn't hear half of it.
I'll have Mark repeat that.
Right. So my motion would be to add a reference in the section of Appendix 6 on costs and insurance, where we list options to address any increased costs. A bullet point noting that to the extent the legislature believes that concerns regarding excess insurance and costs raise concerns about passage of the act, that it may consider caps as a possible solution to that problem. Words to that effect. I'm not
Okay.
trying to draft it on the fly.
Anybody opposed to that? All right, then Alex, you can come up with some language, you and Mark, reflecting that sentiment? Okay, good. Anything further? Alex, do we have anything more to address?
Commissioner Keelan had raised the issue of adding a section to the report that discussed the process that the commission went through. And does anybody have any issue with that?
I thought that was an excellent suggestion. Yeah. No objections? Okay.
Excuse me, Mr. Chair, I agree with that. I think it was very important to include that as some background. I was asked after we all voted by individuals trying to listen that our vote was actually not recorded. The public was unaware of our various votes. I don't understand exactly, forgive me if we're Open Meetings Act relevant or not, but there were a number of questions to me about who voted and how voted and what questions did we vote on. So I had asked before if we could somehow include the questions we were asked and the questions we were asked to vote on. I think that would, at least in my position, which is different from most of yours, it would be very helpful to me.
I think those were included in the minutes. So I know that the meeting was recorded. I don't know if there were technical issues that made that difficult for people to watch or hear the vote, but I do know that the meeting was recorded, and also the vote was fully reflected in the minutes. So there are the minutes that do have the full vote. I don't know that, so just to let you know.
In regard
Thank
to
you.
Commissioner Stewart's comments, I heard today from a representative of one of the counties saying the same thing that she just said. That is that they weren't aware of the vote. I don't know why, I don't know how, but apparently that is the sentiment out there. I think it's more a technical issue, one way or another. Raul, you had your hand up.
Yes, if I understand correctly from GSD, the meeting was recorded. Something happened towards the end on the GoToMeeting platform that you're on now, and it started buffering. And even though it didn't seem like it affected everybody, but there was some buffering and not everything was captured at the end. But I do believe that if it's in the minutes, that would reflect the appropriate votes. So yeah, there were technical issues with the GoToMeeting platform.
Okay, that explains that. Yeah. Then Alex, do we have anything more to touch on today? Anybody else?
I think the last point would be, are we going to have another meeting?
I think we've reached the point where another meeting is not necessary unless someone has a contrary view, because
I
we've
had one more question, Chairman, just to
Yes.
compared to the last question of Sheriff Stewart, at least to ask one more time, you as the chairman, to make sure before we conclude what appears to be our last meeting, is that because we have had numerous public comments since the vote, and even as of today, I think I got a few of them today, that no commissioner has had any type of change of heart per se, or would like to put that out, since this may be our last vote, just to verify, since we did have a whole bunch of comments. I think we had 42 is by what I counted from the last time Alex sent us her spreadsheet since our last vote.
So what is it that you would like us to do, Commissioner Rodriguez?
I think it's just to ask, you Chairman, just to verify that based on what we have heard in the last, since our last vote, that there has not been any change from any commissioner regarding the questions that we voted upon.
Okay, I'll put that question to the commission generally without going through each individual subject. Does anybody have a vote that they would like to record? Hearing none? Okay, thank you we can make that clear as a matter of record. That's a good suggestion. Anything else? Okay, what I see happening.
I have one more thing. My understanding when we talked about the public comment initially was that we would possibly include the public comments with the report to the legislature, but I don't know that we'd ever discussed that, and so I just wanted to know if that was something that the commission wanted to do.
I was going to ask Alex, are you going to include the additional comments in your spreadsheet that you provided, which was really nice to have in terms of being able to look at?
We can certainly update the spreadsheet. So we can certainly update the spreadsheet and either attach that, either just say what the results were in the report, or we can attach it. Another thing we could do is, and then additionally, there's the issue of should we attach the public comments so people will see or the legislatures can see all the public comments. Because while the spreadsheet shows how people voted, a lot of people who did public comment, they did say stuff in addition. So they may have said things in their vote, but then they had other points they made. I don't know what you all think of that, but I think it had come up before, and I wanted to just raise it.
I think it should be included, Mr. Chairman. I think the public comment needs to be part of the package that we present to the legislature.
You want the individual comments or a spreadsheet?
Well, I think in the reason why I asked about the spreadsheet form, will they be included? If they're included in the spreadsheet and it will be the final product, then I think that spreadsheet with those comments should be included with the package.
I agree. I think the entire comment, the spreadsheet, and what people voice should be included. I think the legislature or committees have the right to see both sides of the issue, and they can get a clear understanding of how people feel about it.
Okay.
And I agree with that also. I apologize. I agree also, because I think it was reflective of who we reached. I think we reached a certain segment of population, and I don't think we reached a wide enough segment. So I would agree that they need to be included. Thank you.
Alex, just a suggestion on tech with Raul and the folks at GSD. We might be able to just, if we load the public comment onto the website, we might be able to just include a hyperlink with the chart you put, so that people that want to read the specific comments that were given can click to a spot on the website and look at the specific things that people said beyond the summary. And that would avoid having to publish a stack of however many, but they'd be readily available.
Yeah, it's a good idea. Anyone else?
The spreadsheet wouldn't be a bad attachment.
Exactly.
And just, if I may clarify, if we publish those public comments, that would include the name of the individual submitting them. I mean, it is a public record, right? I'm just wondering if anybody has heartburn with that.
No, I think when you make a public comment to a public entity like us, I think it's public.
Okay, I just want to clarify. I think you're correct, Justice. I just want to clarify. Thank you.
Okay.
I think my only recommendation, Chairman, is for Mark, is if we are going to do that hyperlink maybe on the report, because it's not going to be physically attached to a report, then we make reference somewhere in the report that for further, please see, I mean, that the full comments are available. That way it's well known in the report, whoever reads the report, that those full comments are available at this link in their entirety.
Good suggestion.
That works for me. Could even go in the process section.
Okay, unless we want to stick around and gossip about something, I think that concludes the business of the commission. Yes, Zach.
So, Chairman Dawson, I don't want to keep everybody, but I am curious about when the dissenting report will come out and when.
That's what I was just fixing to reference. Is we are in the process of drafting that. We should have that. Aren't we supposed to be online, Sheriff, Monday or so to finalize?
Yes,
Victor,
I believe Monday
that's
is, yes, Monday afternoon, so.
Yeah,
Okay.
of course, we will need just a few days. The reason being is because just like you guys wanted to see the dissenting, the authors of the dissenting wanted to see what was in the majority. So now that that report's out, that way they can address any issues that are in the majority report that they wanted to address. So I assume when we meet Monday, we'll have a very good, a better understanding of where we're at, and hopefully towards, I'm not going to put it, but hopefully midweek. What I'm thinking is hopefully midweek prior to. We'll definitely get it to Alex before Alex has to get it out so it can be attached.
Yes.
Yep.
Is there a need for another meeting to address the minority report? I don't have no idea what it is. Mark, what do you think?
I'd say we leave it open to call another meeting if we believe it's necessary after we get to see what's in the minority
I think
report.
that's the best way to do it. So keep next Friday open at 2 o'clock. We'll send out an email, or however Alex communicates with everybody, yes or no on that. I hope we do not have to have a meeting. We would only call it if it were really necessary. Otherwise, I'd say we're in adjournment, but we're really not in adjournment, because if you look at House Bill 5, it creates us and tells us to stay in existence until the spring, which I think was designed to cover the extent of the legislative session. And if for some reason our input was necessary during the session. And so we are sort of subject to the call, I guess, the call of the chair for the next several months in that event. During the meantime, we have been asked to appear in front of the some legislative committees, including Senator DeVel's committee, the LFC, and there may be others. And of course, we'll do that in due course. Who knows about the session? I don't know if that will work, but we're available. We're basically at the call of the legislature and the chairs of the different committees, depending on what they want. So I guess let's recess for the day. And thank you all for all you've done for the past several months, and today included. It's been a real pleasure and an honor to serve with you. Raul, do you have any more comments? Nothing for today? All right.
Nothing for today.
That concludes the meeting. Thank you all.
Thank you.
Thanks, everyone.
Thank you.